There you go. You're all set.
All right. Good afternoon, ladies and gentlemen. Welcome to the Housing and Real Property Subcommittee. We have 3 bills we want to discuss today, and all of you did receive the information.
Not in.
Sorry. Hello, David. I'm sorry. So all of you received the information relevant to which bills we're going to go through. And because we have Delegate Shetty here with us now, we're going to start with HB 248. Okay, and HB 248 is a bill that is discussing composting, rights and restrictions for composting. And the composting is for condominiums and homeowners associations. It does not include cooperatives. It's just HOAs and condos. All right.
Is this the bill, Mr. Chairman, is this the bill I really, really liked and said we should pass? I'm just wondering.
Don't you say that about all bills?
Yeah, this is the bill, David, that you talked about. We do have a couple of suggestions on the bill. And so what I'd like to do, first off, hang on a second here, I'm admitting persons as we come in.
I can do that. I can do that.
Okay, so one of the things that Delegate Shetty was so gracious enough to do for us was to send us some information on this bill, frequently asked questions. And so what I'm going to do, you can all see my screen, I'm assuming, is that correct?
Yes.
Yeah.
Cool.
All right. So Delegate Shetty provided this to us, and I'm hoping that all of you on the subcommittee had the opportunity to read it. I'm hoping because she took the extra time to provide this to us. One of the concerns that some had in terms of the composting was something along the lines of nuisance control. And Delegate Shetty was gracious enough to give this to us in terms of how some of these nuisance controls are being abated. What I'd like to do at this particular point, do we have any amendments, Matthew, for this bill?
There was one suggested amendment by CAI, which was to exempt or to have the bill apply specifically to single-family detached homes and not multifamily or townhomes. There was also discussion based on some of my comments about potentially adding the phrase unreasonable restrictions versus just saying restrictions, to make it clear that there are probably, and I believe, and we have Delegate Shetty here, so she can, of course, attest to this, but looking at the FAQ document, it is kind of suggested that there might be reasonable restrictions that could be put in place, such as having the compost covered, or like trash might be regulated in current homeowners associations or condominiums, but that this bill is meant to address unreasonable restrictions, such as making it effectively prohibiting composting, without so much as saying so.
Yeah, there have been some concerns, as I'm sure you know, Delegate Shetty, about the composting, and also concerns about having private entities coming onto the common areas as well. Would you like to address any of that, Delegate Shetty?
Sure, Mr. Chairman, I'm happy to. So, going to first Matt's comments around reasonable and unreasonable restrictions. I think that that's perfectly in line with the spirit of this bill. The intent of the bill was really to address specifically a constituent of mine who lives in a mixed like apartment townhome community that includes, I think, some single family properties as well, but it has an HOA structure, and the HOA was effectively restricting him entirely from having composting. And so he actually participates in a commercial compost pickup, so food scrap collection that he has in a compost bucket that is sealed tight. It is hermetically sealed. And he had this like bucket that was the size of like a large paint can on his balcony. And the HOA prohibited him from doing that. And so I would argue that like a reasonable restriction in that scenario or scenarios like that would be to have, for example, the HOA say, well, you can have it, but just conceal it.
A PhD on that.
However, effectively
Please,
like
thank you.
exempting entire communities like this that have apartments and townhomes as well would still not address the spirit of the bill, which is to enable communities like these to participate in composting the way that they can, which is to collect food scraps and then contract separately with a commercial compost pickup entity, as this particular constituent had been. So I would hope that the committee might consider favorably an amendment like the one that you all have been discussing around reasonable restrictions being allowed, but I would really encourage the committee to please consider not exempting townhomes and apartments, especially since apartments in particular that have like balconies, there are no homeowners that are doing composting on their balcony. What they are participating in is commercial food scrap pickup. And so if you exempt them, we will continue to have this ability of common ownership communities to restrict these particular homeowners from engaging in composting. And that's not what this bill seeks to do.
Yeah, we had similar language that we put onto HB 322, which was the low impact landscaping bill. So what I would suggest is that perhaps, if it's okay with you, Delegate Shetty, that maybe we could have Matthew put something together to help us provide some reasonable restriction language on here, which I think might make it consistent, like I said, with what we passed with HB 322. Is that okay with you, Delegate Shetty, you think?
Yes, Mr. Chairman, and I would be more than happy to work with you, Matt, on that to the extent that you would like for me to.
All right. Let's open up discussions to the subcommittee members. And after we have discussions with the subcommittee members, I'll then open it up the discussions or questions to stakeholders. Anything from subcommittee members? Let's go with Delegate Terrassa first, and then Delegate Lehman.
Yeah, thank you, Mr. Chair. I just wanted to say I agree with that. I think adding the reasonable, or whichever way it is, was talking about makes a lot of sense. I think we talked about that last week. I agree, though. I'd really like to see us figure out a way to keep in townhouses and apartments. I think it's really important, and I think if we're taking what Delegate Shetty described of sort of hermetically sealed, a container on your deck or on your porch or wherever it is, I think should certainly be reasonable. And I really would like to see us, I mean, as a townhouse resident and former HOA president, I'd really like to see a way for us to get that to work.
Okay. Well, we'll have Matthew work with Delegate Shetty to put something together. We'll now have, in order, we have Delegate Lehman and then DFH after that.
Thank you, Mr. Chairman, and thank you so much, Delegate Shetty, for joining us and keeping this conversation going.
One comment and one question. So I totally agree with Delegate Terraza. I think, this bill is written in a way that's meant to be inclusive. And so I think to limit it to single family homes would be discriminatory, frankly, and there's no need for that. As someone pointed out in our last subcommittee discussion, in a lot of communities now, single family homes are incredibly close together. For all intents and purposes, they might not be attached, but they're close to being is in close physical proximity as townhomes. So that proposal does not make sense, I don't think, on any level. But my question is about the issue that was raised toward the end of last meeting when someone asked whether the way the bill was written would residents be precluded from bringing outside food scraps from somewhere else, from their workplace or somewhere else. And Mr. Mickler seemed to think that the bill did not really address that. Is there, Delegate Shetty, do you want to comment on that? Do you think there's a need for that language to specify that, people, that there should be limits on people bringing in food scraps that are not generated in their own home?
Well, I really appreciate that comment and that question. So, Delegate, thank you for raising that. So, in order to put the FAQ document together that we circulated to the committee, we watched the subcommittee's discussion intently and understood that this was something that many members on the subcommittee had some concerns about. And so we did some research, and it's our belief that in many circumstances, one, it would be really impractical for somebody to do that. Like, say, for example, if somebody works in like a restaurant and they want to bring in all the food scraps collected there to avoid them going to the landfill, there we go, thank you, then they bring them home. In one instance, it's really impractical to do that, right? Because that's a very large quantity to be hauling home. In many instances, the size of, so there's two types of composting, right? There's the type you do in your backyard, and then there's the food scrap collection that you then hire an outside entity to come and pick up, like a bin that's hermetically sealed weekly, the way that you have like recycling pickup or trash pickup weekly, right? In the food scrap collection arena, that is highly regulated by state and local laws already. You have to maintain your compost pile, and if it becomes a nuisance, you can get really seriously dinged for that. So somebody is unlikely to bring in like a large quantity of food scraps from the outside to put into their backyard compost pile, because it could potentially exceed the size that would legally be allowed for them to actually like appropriately manage without it becoming a nuisance. Now, in the food scrap collection, so I can give very personal experience on this. Like, when you contract to do food scrap pickup, you're contracting for weekly pickup of a certain size bin. And so for a specific price a month, you get like a smaller bin that is like the size of a large paint bucket, or you can get like a slightly larger tote that is larger. If I'm bringing in food scraps from outside, I will exceed the capacity of my bin and will not really be able to manage that anyway. So like, I'm unlikely to do that because I already generate enough food scraps cooking at home for my 3-person family to be able to manage that. So I think, to the extent that the committee is interested in putting in language, I think it's certainly doable, but I also think that language could potentially be difficult to enforce. And so, I think there's that consideration as well. But I would just rest on the argument that it's really impractical and in many circumstances probably illegal anyway. But thank you for raising the question.
Right, and thank you. And I agree with that. I had read that answer, but I would just say too, you could get into what about food consumed away from home, not brought from a restaurant, but say your family goes out for a picnic, like where would you draw those lines about something
Right.
consumed away from home versus brought in from a different source, and
Right.
it would be very difficult. So thank
Yeah.
you. Thank you.
We'll go now to DFH, and then after that, we'll go to Delegate Healy. David?
Thank you. So two things. One, as I did say last week, look, from a environmental and climate piece, this is something that we all need to start doing. I know that there are people that are not comfortable with it. I'm sorry you're not comfortable with it, but this is what we as a society need to do. All of us need to pull our own weight. These are the same conversations that were had when we started recycling. So it's coming, and we might as well wrap our head around the fact that it's coming and do the best job we can to craft this bill and other bills in such a way that they work. We can talk about, a satellite coming out of the sky, or we can talk about all the if, ands, and buts and what ifs. And I hear this all the time on bills, like, well, what if a meteorite comes down and lands on your car? Yeah, okay, what if? Let's stop talking about the what ifs and let's start talking about how we pass the bill. That's all I have to say. Thanks.
Is that followed by, isn't that so?
It is. Thank you. Isn't that so, Chair? Thank you. I'm sorry. Thank you.
Ann?
Yeah. Oh, thank you. Thank you, Mr. Chairman. I just want to get clear. Is this about the food scraps in the sealed containers, or is it about the compost heap on common areas, or in a community there, or is it both?
It's both. Thank you for the question, Delegate. I really appreciate it. So it's both. Right now, the bill as structured was intentionally, or initially rather, inspired by a constituent, as I mentioned, who lives in a common ownership community who is having challenges with his HOA with food scrap collection composting. So he was not doing compost piles on his balcony. And like I said, nobody really does that, right? Like it's not feasible. It wouldn't actually work. And it would be kind of more to manage than necessary. But there are many homeowners who live in apartments who do food scrap collection. We were able to get, to prepare for this discussion, we were able to get numbers from Compost Crew, which is one of the commercial compost pickup companies that's probably one of the larger ones in the region. And if I'm not mistaken, and they're based in my district, so I work closely with them on a number of compost related issues. But they serve currently about 1,500 homeowners who live in apartments. I
have a couple questions. I have to probe a little bit on some of this, just to see what the answers are. If you have a company coming in, I live in a municipality where they do collect, the city collects. But if you're in a townhouse, or if you're in a condo apartment, there's how many come in, how big are they, how intrusive are these, like trash trucks, like gigantic, like that you see, or are they smaller? Is there a balance? Is it every day? I guess those are the kind of restrictions that we're looking about, how we make it reasonable so that people don't go, get upset about.
Right.
Intrusive
noise and I hear that. To be honest, in the time period that I've been working with Compost Crew, like from like a homeowner's perspective, I've never actually seen their truck. That's a good thing. Pick up on a day that like I usually am at work or not. I just don't happen to be at my window when they pick up. So I'm not really sure. I have seen compost pickup trucks in Annapolis, and they seem to be slightly smaller than regular trash or recycling trucks, but I don't know if that's like common, and it might vary by compost company.
I'm sorry, I'm just trying to, if you could just give me like some short answers. I'm just trying to figure out how this practically works.
So typically it's weekly collection, like trash or recycling. And in an apartment or townhome community, they usually have like a larger tote that they would put by the trash or recycling bins, and they would just go there to pick it up, and then they would leave.
Oh, okay, that makes sense.
What is, if I could, to piggyback on what Delegate Healy is inquiring about, can you give us, Delegate Shetty, the name of a company that does this so that we can follow up to get some of the mechanics on how this works. Is that possible?
Yes, I would be happy to. I can email it to you all. But Compost Crew is based in my district. Ben Perry is the president. I work closely with him, and I'm happy to send his contact info.
Yeah, I think what Delegate Healy is trying to get to, and I'm trying to put words in your mouth, Ann, but how the mechanics of this whole thing works.
That's definitely part of it, but I also want to understand how broad the legislation is. If every homeowner can get a different company, you'd have tons of trucks coming in all the time. But if the whole association, contracts with one company that pick this up on a regular basis, that would probably be less intrusive for the whole community. But does the legislation give each homeowner the right to contract with anybody they want to?
Yeah, it does.
I think currently homeowners have that right. So that's not necessarily being changed either way. But I think what really is being sought to address here is that, it wouldn't be outright prohibited.
Okay.
Yeah, and I think that Matthew chime in here, the way that the legislation is currently written, each individual lot owner or unit owner could in fact have their own separate collection company. Matthew?
Yeah, I don't see anything that would prevent each unit owner or lot owner from having a separate company. I mean, I think as a practical matter, if there's one operator in an area, or if you see somebody else is using one company, you might, sorry, I don't mean to interrupt.
No.
You may use that company. However, I will note in terms of the collection, there is language in the bill currently, top of page 3 and bottom of page 3, about not unreasonably impeding the ability of a private entity to access the common elements for the purpose of collecting organic materials. So there, I wasn't too concerned about the reasonableness provision, because a reasonable limit, I think, could be placed on these third parties to access common elements for pickup purposes. It just couldn't unreasonably restrict.
Okay. You good, Ann?
Thank you.
All right.
Some more.
Yes. Delegate Terrasa?
Yeah, just as a quick follow-up to that, I would say, I think Delegate Shetty sort of said this, but they can do that now. They can contract with folks now, but I guess there could be restrictions on it. But as a former HOA president, if I were trying to restrict that in any way, I would contract with a company, and if I had 10 residents who were doing it, you'd probably get a better deal. And then people would be more likely to go with that company because it was cheaper, and then you'd only have one truck coming through. So I do think there are ways to avert that problem if it becomes a problem in a community.
Okay, thank you. And we'll get some additional information here and get that to the subcommittee as well. I'd like to hear now from any of the stakeholders, if you have any additional comments from the stakeholders relevant to HB 248. Anyone? Tommy?
Thanks, Delegate, and thanks, committee members, and thank you, Delegate Shetty, for bringing this bill. I do agree personally that this is an important issue, and I don't want CAI's testimony to be construed in a way that I guess has been termed discriminatory. What the issue really is that the structure of some of the housing units on the properties, just by the connection of their common areas and what composting may or may not bring in the terms of wildlife attraction and things along those lines. If there's some type of infestation, it becomes the parties in the houses then fight over whose responsibility is it to take care of that infestation. Is it the person who has the compost? Is it the person's house who's been infested? Is it the community association as a whole? And so while we're not trying to be discriminatory, we're trying to recognize that composting, at least as described in the bill, was not what we envisioned as the hermetically sealed containers. It was more of the piles, the outdoor. I have 3 of them myself, the outdoor, either tumblers and or squares. So that's where we were looking and why we had reservations. We do think there's moves in associations to use common areas for community gardens, and we don't see why we can't evolve in the community composting as well. But, you know, I know it's been put as what ifs, but I can say from my own experience that my neighbor likes to compost, you know, beef bones. That's not how you compost. That's just not what goes in a composter. And so we have a lot of responsible composters on the call, but then we have a lot of folks who are either just wading into it or just do it kind of on how they feel. And that's the worry we have. And speaking to the outside food scraps, while it is impractical, the bill specifically talks about the end use of the compost, not the actual product going into the composter. It's for the homeowner's end use. That's what we're talking about, the soil that's created for the end use. So we didn't look at the front end as to what is or is not going into these composters. And that's where another concern comes in, again, for the attraction of animals and things of the like.
You have any suggestions, Tommy, in terms of how to, tighten it up a little bit without restricting it just to single family?
Yeah, I mean, I appreciate the reasonable restrictions. I do think that is fair, and I think that's a consistent move by the committee as a whole, based on your other bills you debated on these issues. You know, what is a reasonable restriction is going to become, I guess, the next battlefront on this issue. And you'll have to understand that there's going to be changes that have to occur to the bylaws and the declarations to actually get these restrictions in place. And as you know, in this committee hears all the time, that's not the easiest process in the world always. And so we're worried that even if we get this, you know, reasonable restriction kind of language, how we can actually implement it when you don't always have the full engagement of the community in your board meetings and in your bylaw changes.
Okay.
Well,
Well,
we'll continue to work with you. I think we agree with the intent of this bill wholeheartedly. I think that shows in the testimony submitted. It's just the mechanics of how this will work in mixed communities.
right, and that's what we would like to get to, the mechanics. That's one of the things that Delegate Healy was asking about. Jen?
I just want to clarify something with the bill sponsor. Maybe I'm wrong on this, but does this require restrictions or just prevents unreasonable restrictions?
As drafted, it prevents unreasonable restrictions. So there's
So I don't think that, oh, sorry, I didn't mean to interrupt. I just didn't think there was a need for them to pass restrictions. I think it's a matter of preventing boards from going out and passing unreasonable restrictions on it.
Right, Delegate. So to respond to that, if like a homeowners association currently has in its bylaws active restrictions against composting, then they would be required to amend their bylaws, but otherwise they would not be required to adopt any specific provisions to comply with this bill as written.
So Mr. Thompson, is your concern that a lot of them already have those in place? Is that your concern?
I mean, I think some do. It depends on when the community was established. I mean, a lot of your communities in the 70s and 80s, when these were established, they didn't think about composting when drafting their, you know, bylaws for the community to coexist. I think as this issue has become more in the forefront of our minds, you're starting to see more restrictions either be put into place or to just kind of streamline how the process will look in the community. So I think there's going to have to be either restrictions added for those communities that have not addressed it to be reasonable, or there's going to have to be, you know, a review of current restrictions and an editing process that will need to occur if this passes. And you know how that works, Delegate. It is a process when you bring stuff like this before the board, and a lot of people, again, aren't familiar with this and are nervous about it and have a whole bunch of reservations. And
yeah, no, I understand that. I just don't see the urgency of passing restrictions. I think that's why we need to get the bill in place, is so that as they're putting those restrictions in, we make sure they're not unreasonable.
Right.
You understand the complications of passing any rules in a community.
Sure, and with unreasonable not being defined, again, what's reasonable to you and I may not be reasonable to someone else. And then I don't know what the mechanism for true enforcement of this is, but, you know, we worry that we'll run afoul of that as a community.
Well, we all know that Jen is totally reasonable all the time.
Always.
And
You're on mute.
Okay, here we go. All right. Delegate Shetty, you mentioned earlier that there are already state and local regulations on the
good
kind of
point.
outdoor composting that's also part of this. Do you have reference to what those are, so that, I mean, maybe we could put like some kind of reference in the bill, Matt, to the state regulations on these, so that they can't just do it in their back, you know, in any open area. They have to follow some kind of standards. If there are standards that exist either at the state or local level, maybe we could make a reference to them in the bill. What would you
That's
think?
very, very good point, Ann. Very good point. And I had a note here on the exact same thing, because even Delegate Shetty alluded to it in the document that I screen shared, that there are current regulations. So let's try to figure out, if you could, Matthew, what those current regulations are, so that we can at least have that as a reference point additionally.
Yes, and I would
Good
recommend,
point, Ann.
it's an excellent point, and I would recommend, Matt, like specifically including, like as Delegate Healy very wisely pointed out, including reference that, you know, compliance with state and local regulations around this is incredibly important. Thank you. That's a great point.
Yeah. And sorry, I don't mean to interrupt.
Go ahead, Matthew.
I do think it could just be as simple as that. I think even,
Yes.
and I hesitate to keep coming back to HB 322 because there was a little bit more detail and a little more depth there. But if I'm recalling correctly, I think there was something to that effect in HB 322, or it would be simple to add even just a blanket statement that any activity would be subject to existing state and local laws on composting. I'm kind of spitballing what that might look like, but just a general statement.
No, I think that's a really great point. I mean, I know, for example, and I referenced here, and I think I hyperlinked to maybe some of them, Matt, if that's helpful, in the FAQ document. But Montgomery County has specific requirements over the type of bins that you use, like very specific, clear stuff. And so, I mean, I think like if you just make that reference to existing state and local, that's really helpful.
We'll put that in. We'll get that documentation as well. Jen?
Yeah, that was pretty much what I was going to say, because having also worked a lot on composting laws locally, just happens to be the area for me. There's so many, right? There's so many different ones. I wouldn't want to refer to specific ones, but I think Matt's reference makes a lot of sense.
Great. All right. Any additional comments from stakeholders and or subcommittee members on HB 248? All right, great. We'll get back to this next week, ladies and gentlemen. Right now, let us go to HB 499. 499. And HB 499 is a bill that is creating a fund, and it's a rental housing restitution fund. And currently the way the bill is written is that the fund would be used for rental assistance, and it would be used for legal assistance as well. There have been some suggested amendments to the bill, and the amendments that were suggested were by AOBA, MMHA, and also by the Attorney General's office. Let me first off go to Matthew so that Matthew can, if you want to, Matthew, explain some of the amendments that have been offered.
Certainly.
Go ahead.
Oh, certainly. I would perhaps, just for convenience sake and because it's a small amendment, start with the Attorney General's office request for discussion purposes. I can Either I could share my screen or, oh, well, there we go. We're gonna.
Okay.
Okay, and that is HB 0499-680-016-1.
And this is, in fact, the Attorney General's amendment suggestion that has been put to the bill. And I'll scroll down to the portion where the Attorney General right here. You want to discuss that, Matthew, a bit?
Sure. I will just note, it looks like your screen may have frozen, at least for me. I'm only seeing your files. But generally, if members of the subcommittee have the reprint before them as well, it was sent in an email this morning. And the amendment,
hey, hang on a second, Matt. Is everyone seeing the reprint or just the files?
Just the files.
Oh, why is that?
I don't know.
Okay.
I saw the one file that said Marvin Holmes Friends, and I didn't see a sub file with my name on it. I was confused.
I think actually it was empty.
Everyone's got jokes, I'll tell you. All right.
okay,
we go.
now I can see it. I believe everyone should be able to see
All
it.
right. Thank you.
Okay, so this amendment was based on the Attorney General's office comment that they don't currently administer a fund such as this and would need support to do so. And so they wanted to use the funds available in the fund, not just for rental assistance and legal assistance to individuals facing potential rental residential property eviction, but also to for costs incurred in the administration of the fund, which they are responsible for.
Mm-hmm.
That's pretty much
That's pretty much
in a nutshell. Yeah.
Yeah. And ladies and gentlemen, the funds that would be coming to the Attorney General's office for this restitution fund would be a result of inquiries from cases of that the Attorney General's office would be involved in. I see that we've got representatives from the Attorney General's office. Do either one of you want to chime in on the amendment that you put forward?
I think Matt covered it pretty well, but we don't currently operate any kind of fund like this, and in order to both administer the fund and to dole out money for the purposes involved, that would require that we have staff dedicated to doing that. So we believe that you being able to use part of the funds for covering those staff expenses would be necessary.
Well, you've got Karen, and she can work 24/7. She doesn't need to go to sleep at night. I mean,
She already does.
Yeah.
We would have to. You would have to make an amendment to add extra hours to the day. So.
Oh, that's the next bill coming up.
Okay, thank you, Mr. Chairman.
There's also in light of the same topic, in terms of the fund, there's also an amendment that actually puts the funding to DHCD and not to the Attorney General's office. Any discussion that you want to have on that amendment that takes the funding away from you totally and puts it to DHCD? Any thoughts on that?
We would defer to the wisdom of the subcommittee on, whether they would rather have us administer it or whether, it makes more sense for DHCD to administer the fund.
Okay.
But I guess if it goes to DHCD, we wouldn't need the staff to administer the fund.
Well, I'll just wait until after we make our decision before I put the bill in to extend the 24-hour day to a larger work day to 36 hours per day or something, so we can work Karen a little bit harder.
Chairman.
I heard someone.
Mr. Chairman.
Oh, Barry, yes, sir.
Yes, I'm curious, is there anything in the bill that would give legal assistance to the landlord? I mean, I've been a landlord for a number of years on a couple of properties. And when I go before a judge, it's usually after weeks or a couple of months of trying to work with the folks. And now suddenly, if I go before a judge, the landlord is going to, the renter is going to have legal assistance? That doesn't seem fair.
That
person would not be there if they paid the rent.
Correct. In the bill, as currently written, I think the legal assistance is suggested, at least, to be for the tenant's use. Matthew, you want to expand upon that discussion?
Yes. So looking to current subsection G, which I believe is on page 3, the fund may be used only for rental assistance and legal assistance to individuals facing a potential rental residential property eviction. So that most likely would not, well, it would not cover the landlords, or I believe it's not the intent that that cover the landlords, because it's the individual who's facing eviction from the property.
Seems a bit one-sided, Mr.
Answer your
Chairman.
question, Barry?
More or less, but it seems rather one-sided from where I'm sitting.
Sure. I understand. Ann, did you want to, I see your hand raised, Ann.
That's a mistake. That's from before. Sorry.
I'm sorry, Ann Seacott.
Thank you. I didn't know if it was appropriate to weigh in at this time.
Sure. Go ahead.
Just very quickly. I mean, I think that for the legal assistance part, there are groups like Legal Aid, like the Public Justice Center, like the Pro Bono Counseling Center, that already have a presence in some areas of the state. And so I think that that's part of the intent of including legal assistance there to be able to support those groups. I think this committee, the subcommittee is well aware of some of the challenges that especially the Legal Aid has had this year because of all the issues affecting their funding. So I think that's partly what this is in response to.
Okay, let me go to Delegate Wyville, and then we'll go to others. Right now, Delegate Wyville, you got your hand up.
Yes, thank you. What is the source of the money for this fund?
That's what I was going to ask. That's what I was looking
if it's in there, I missed it.
Yeah, it's in there. Matthew.
Sure.
From the Office for Protection.
Sure. At top of page 3 of the bill as drafted, the fund consists of, and these are funds coming out of enforcement actions or settlements related to the Maryland Consumer Protection Act for unfair, abusive, or deceptive trade practices associated with rental residential properties. And unfair, abusive, and deceptive trade practices is defined in the commercial law article. It's Title 13, subsection 3. And Title 13 is as I understand it, the Maryland Consumer Protection Act. Now, there are, of course, representatives from the Attorney General's Office Consumer Protection Division who could elaborate further on what that means, because it's a fairly extensive definition.
Are these like class action suits or something that are settled, or what?
I'm sorry, I missed the first portion of the question.
Are these like class action suits that are settled, or what?
I think we'll have the Attorney General's Office expand upon it, but it's from investigations and enforcement of the Consumer Protection Act.
Right.
Steve?
Go ahead, Mr. Chairman.
Go ahead, Steve.
Yeah, no, these would be from actions brought by the Consumer Protection Division. So enforcement actions, settlements that we reach involving your residential real property. So it would not be private class actions.
Does that answer your question, Bill?
Yeah, but I had another one. So we do have the other amendment here, which would the fund would just provide rental assistance, not legal assistance, I assume. Are you getting to that one later, or because that kind of answer?
Yes, I was trying to go through them in a kind of a real systematic process. We need all the questions answered one at a time, so to speak,
But if we agree to that amendment, it kind of makes the other amendment with the state's attorney.
You are correct. You are correct.
Okay, all right,
Uh,
thanks.
That was my
go ahead.
mistake for starting with OAG, because that's correct. The OAG amendment could become irrelevant depending on other amendments that could be adopted, but all the amendments, I believe, should be discussed before any particular
Simultaneously, right, I agree.
action.
All right, thank you.
Delegate Healy?
Yeah, the question I have is about the funding as well. This money apparently exists now. How large is that? How much money are we talking about that's in this fund that it would be coming from? And how is it being used now? So what's it being moved from doing to do this?
I really don't have any clue how large we're talking about, but it is any money that we would currently get in civil penalties in any of these actions would be going to the state general fund. So if we were to bring an action, we would usually try to get restitution for consumers who've been harmed. That wouldn't change. I would still go to restitution. As the bill is drafted, any costs that we would obtain for use of the action would go to help fund the costs that the division incurs in bringing in action. But this would affect any penalties that we would obtain, which, like I said, currently would go to the general fund. And instead, this would now go to the housing restitution fund.
All right, thank you.
Jen?
So I'm actually somewhat confused about which amendment we're discussing. Are we discussing all the amendments at the same time right now?
I think it's probably appropriate right now for us to discuss all of them in a group.
Okay.
Because they do kind of impact each other.
Okay. Well, I guess I strongly believe that we should be keeping the legal assistance piece in there. And I don't think it's fair to assume that somebody, just because there has done something wrong. I think that is what an attorney is there to do, is to represent them and for that to get worked out. I think that's an important piece. And I guess I'm also wondering for DHCD, if they would be supportive of it going to them. I mean, my gut is it's better in the Attorney General's office, but would they still support the bill if it was moved? I don't know who's asking for it to get moved to DHCD, and if
that
supportive of doing both of those functions.
The amendment to move the fund administration to DHCD was part of the MMHA and AOBA amendments. The MMHA and AOBA offered almost identical amendments. There's one additional amendment in AOBA, but it's actually, that language is otherwise stricken as part of one of the similar amendments between the two bodies. So they do read as identical amendments.
Okay, well, I just wouldn't want to move it to a department that's not interested in doing that. And then they might be also asking for additional funds to administer that, in which case my thought would be just to leave it in the Attorney General's office.
Oh, we force folks to do stuff all the time. So what the heck? Hunter, I see you here, Hunter, from DHCD. You want to give us your information, Hunter?
Sure. So we don't have any position on the underlying bill in general, but I would point out that if the amendment is adopted to move it to DHCD, I would just recommend that on page 3, line 9, where it's talking about the purposes of the fund, that it also be expanded to include operations of the fund. And then that would allow us to be able to implement it. It looks like it's written, the purposes are written broadly enough that essentially that fund could be a fund source for existing avenues that we provide funding through. So we're kind of agnostic on that part. But we already provide funding to local jurisdictions and nonprofits and affordable housing developers for rental assistance. and we already provide funding to support legal assistance. So that's not an issue, but you would need to include operations of the fund as an allowable purpose so it could support itself.
So you would not be objectionable to having the funds directed to you as opposed to the AG's office. Is that correct?
Whatever the committee decides.
But I guess as
Okay.
a follow-up, my question would be why, or would we consider moving it? Like, if you're not asking for it, then I'm not sure why we would.
Well, but the funds being put towards DHCD was not something that either the AG's office asked for, nor did DHCD ask for. Okay.
No, I understand. I'm asking the wrong person. I'm sorry, Mr. Chair.
Okay.
My question is still, why would we do it?
I would just say, and it wasn't our amendment, but we do already do similar functions, right? We're already providing funding for rental assistance, for legal assistance. So I think if we're just looking at this as another fund source, we would be able to direct it to the providers that are already providing those services. I don't know. I don't know what OAG's capacity for that is, or what
I think that was the reason why the amendment was put forth by MMHA and AOBA, was because DHCD is already kind of doing some of these things already. We can have them, DHCD, and MMHA, speak directly to it since they're here as well. Aaron, you want to go ahead?
Yes, thank you, Mr. Chairman.
Oh, can't hear you, Aaron.
I'm sorry.
Go ahead.
That better? Sorry, my apologies. Mr. Chairman, yes, it was our amendment suggesting and not throwing my good friend Hunter under the bus. But really, as Hunter mentioned, there's already a process in place from DHCD to administer these funds. You heard from Mr. Sakamoto Wengel that they don't administer these funds. This is not something they typically do in their practice. So what we're saying is, if you're going to target and hold the bad actors accountable, have those funds limited only to rental assistance, because that's the most important. The legal assistance is a separate issue, quite frankly, that the General Assembly is taking up in a number of other bills, not before this committee. So limit it to rental assistance and have those funds administered by DHCD, which has the structure in place to do so. So that was sort of the thinking behind it.
Does that kind of answer your question there, Jen?
It does. I mean, my concern, that was sort of my concern, is that I think the legal piece of it is very important. I would not agree with the statement that that's the lesser piece of it. And if you're going to move it over to DHCD with the assumption that it's only the one piece, I would object to that.
And Delegate, I did not mean to say in any ways that legal assistance is lesser than rental assistance, but we do know that rental assistance actually will stem evictions, right? And if you're going to target bad actors, which we're all for, target the bad actors through the Consumer Protection Division, but make sure that those funds are for rental assistance. Again, there are countless bills dealing with legal assistance.
Right. With all due respect, we also know that legal assistance, I don't have the numbers in front of me, but legal assistance actually has a huge impact on whether people are actually evicted. And I can get those numbers for you if you need, but it has a huge impact on whether people are actually evicted.
I would love to see that report and where it stems and who authored it and who paid for it.
I may also add that there are other pieces of legislation that is being put forth right now to provide additional legal assistance. Not that I'm attempting to circumvent the discussion here on the two-pronged purpose of this bill, which is rental assistance and legal assistance, but there is other legislation being moved right now, being discussed, I should say, that do provide legal assistance as well. I'm going to go to Delegate Weigel and then Delegate Lehman.
Yeah,
Bill?
just to follow up on that conversation, do we know what percent of landlords and what percent of tenants are represented by legal counsel in these eviction notices? Because I guess my experience here locally is normally, I don't think either party are normally represented by legal counsel.
Do you want to, Aaron?
I don't have the exact numbers in front of me, but I think the statistics do show that landlords tend to be more represented than their residents. So I think that that's a fair statement to make, but I'll follow back up with you and get those statistics.
Yeah, are those large landlords or small landlords? I mean, I'm thinking of the mom and pops. I don't think they're normally represented by attorneys, but
Yeah, they may go in by themselves instead.
I can go from personal experience because I'm in the profession. When I have to go to court, I go by myself. I don't use an attorney, quite frankly. And some of the smaller landlords that I see in the court systems are by themselves as well. But the larger ones, as I have seen, not that gives you any numbers or anything, are represented by attorneys. But what I don't know if those numbers are available, and we'll find out from others as well. But let's go now to Delegate. I'm sorry, Bill. If that answer kind of take care of it for now, Bill.
Yes, thank you.
Delegate Lehman.
Thank you, Mr. Chairman. So on the question about, it would be interesting to see statistics on tenants going to court. I think it's safe to assume a lot of them don't because they don't have access to counsel, and the prospect of representing themselves is overwhelming. It would be for a lot of people, including I would imagine many of us in this conversation. But I have a question about there's language, I guess a question and a point to make about the language on the last page of the bill that talks about the fact that this fund is meant to supplement and not take the place of other forms of assistance. You know, if I'm reading that right, it's supporting the notion of a different and separate fund for both legal purposes and housing assistance. And I think, you know, at least in my mind, that makes the argument that this should be kept in a separate, you know, place in state governments, i.e. the AG's office rather than DHCD. It's really, I think, drawing a line and clarifying that this is a fund that is, you know, meant for, especially the legal part of it, a different purpose, and should be not be mixed up with or confused with other housing assistance monies in DHCD or anywhere else for that matter.
Well, I think that some of the discussion has been taking place because the bill asks for money to go for two different types of programs, so to speak. One is rental assistance, and the other is legal assistance. So the bill asks for two different types of programs. That's why I think that's why MMHA and AOBA suggested DHCD.
And that's fair, Mr. Chairman. I would just say, but it doesn't call for those two different types of assistance to be split, you know, between the, you know, two different programs or agencies, and I make it more complicated. That's just my 2 cents. Thank you.
All right. I haven't forgot you, Ms. Seacott. I don't take Delegate Healy next.
Thank you, Mr. Chairman. My question, as you may know, my husband for many years was the executive director of legal services in Prince George's County, community legal services. And they did a lot of this kind of work with pro bono attorneys. The question that I have is really about jurisdiction for our committee, because I think if it were a standalone bill on
rental assistance,
it would probably be in the Judiciary Committee because it's got both of them together. It's before us, and I don't know that we have the expertise to really know. But the other question is, how much money are we talking about? Is there enough money to pay for both of these things? And if it's only a small amount of money, then we might want to look at how that would be dealt with, because there are other bills that deal with standalone bills that deal with the legal assistance. And I'm sure that I haven't looked at them this year, but I know that they always identify a funding source of some kind. And I don't know if they're tapping into this same funding source in that legislation or not, but I think we need to do a little research to find out how all this stuff interacts with the other committees, the other Judiciary Committee, in fact.
I think you're exactly correct, and in that we do need additional information in terms of other funding sources from, like you said, for legal assistance. I think that there may be a piece of legislation coming forward that might increase the filing fees for these kinds of landlord-tenant actions, and the filing fee increase money might go to legal assistance. I'm not sure if that filing fee funding would go to rental assistance as well, but I do think it would at least go to legal assistance, which would then kind of take it back, like you said, to reduce our exposure as housing and real property or environment and transportation, maybe to a single pot, and not get out of our lane of expertise. And so we would could primarily deal with rental assistance and not legal assistance. I think that's where you're kind of where your head is going, I think. But we can look at other legislation and see how that affects this one as well, because there's quite a bit going on all at the same time, simultaneously together at once. I'm sure you're all aware of that. Ms. Seacott?
Thank you. Just very quickly in response, I am making sure to get to you all as soon as possible those numbers that you've asked for related to the percentage. It's a very, very small percentage of tenants who are represented. For that very tiny percentage, I know this is in the Public Justice Center's testimony on the bill, there's a very high percentage among that very tiny percentage of tenants who benefit from being represented. So we'll get you those numbers.
If I could ask you a question on that,
yeah.
Is this the information you're giving us? Is that for the initial case of failure to pay, or is this for tenant holding over, or what the numbers are relevant to what part of the legal process?
I am pretty sure it's failure to pay rent, but I promise you when I get you those numbers, I will clarify that very particular point and make sure that it's defined if it's very broad or limited.
Thank you very much.
And then,
I didn't mean to cut you off. Go ahead.
Oh, that's okay. That's okay. Just two quick other points. One is, I think that the point of this legislation, just a little bit of history, just because I've been related to it on totally different topics. Senator Delegate Rosenberg, established the original cigarette restitution fund, 25 plus years ago when the states were involved in lawsuits against big tobacco. Just 2 years ago, Delegate Rosenberg passed a bill to create what is called the Opioid Restitution Fund. And that is to be the recipient of dollars that come to the state in suing pharmaceutical companies. So I believe that this is sort of the same idea, that in these suits against some of these property management companies, when there is success by the state, here's a pot where that money can go to in order to make sure it's getting to remedy some of the problems caused that led to the lawsuit. So I don't think that this committee needs to worry about so much the technical, legal assistance or the rental assistance. Clearly in the bill, that's something that whether it's the AG's office or the HCD, they would be able to come up with regulations on how to distribute and have a process around that. I think the reason you all have this bill is as a place to say, you know, here's where these funds should go, so that they don't just go to the general fund. I think that's sort of the proposal there.
Thank you. Mr. Wiggins, did you want to?
Just really quickly, Mr. Chairman,
Sure.
You mentioned the 3 surcharge bills. Those are House Bill 478, House Bill 729, and House Bill 30.
Slow down. House Bill
478, 729, and 31. So there's 3 of them.
Okay.
One of which is the Attorney General's.
Okay. Thank you, Mr. Wiggins.
Yep.
All right, we'll take a look at those. Obviously, ladies and gentlemen of the subcommittee, we have additional work to do on this particular bill. I am not suggesting at all that we start looking at passing amendments and passing this bill just yet. We've got to dig a little bit deeper before we make some additional decisions. I think you all will probably agree on that. Any additional discussion on HB 499 before we move on to the third bill? Thank you, ladies and gentlemen, for your patience. Let us now go to HB 593. And right away, we're going to acknowledge the fact that this bill does have a very significant sponsor problem, but we'll discuss it and talk about the bill anyway. Since I have no friends, as was brought to the attention of the committee earlier, we may as well just kill this bill right away.
Second.
Just so you know, Mr. Chair, my comment wasn't that you don't have any friends. My comment was that you didn't list me as one of them.
Oh, I see.
That was my comment.
I got you.
Which I think Delegate Weibel picked up on and then put his thumb on it and just ground me into the ground.
Yeah, I did. I apologize. You all kill my bills anyhow, so it doesn't matter.
I stand corrected, David. This bill, ladies and gentlemen, is obviously sponsored by our own David Frazier Hidalgo. And this bill is relevant to meeting requirements, and the meeting requirements that the bill is discussing are for condominiums and homeowners associations only, and not the other third leg of our common ownership communities, corporations. Corporations.
Cooperatives.
There you go, co-ops. There you go. Okay. Largest in the state being in Ann's district.
We did pass this bill prior in the same posture, I believe.
Oh, good.
And this was in last year, I think it was.
Absolutely.
It was 2019. That was HB 1037, and the vote in the House on third reader was 136-3.
We need to find those 3 people.
They may not even be here anymore.
I'd be surprised, looking back at time, I'd be surprised if Neil Parrott wasn't one of them. If Delegate Parrott wasn't one of them.
We can almost be rest assured that our own in-house Dr. No was probably one of them. And you're saying, DFH, that this is an exact same posture that was voted favorably in the House in 2019. Is that correct, Matthew?
Yeah, that's my belief. It's the same exact posture. I'm sorry, Matt. I didn't mean to.
It is. I reviewed the 2 copies next to each other, and it's in the same posture. Not to put a fly in the ointment, so to speak, but there is one amendment that was recommended by CAI. This was one of the ones that I mentioned I would do by voice. It was in CAI testimony, and the amendment would simply, the amendment would change from 15 days, the requirement that a subsequent meeting not occur, or not less than 15 days after the initial meeting. It would put that in line with the notice requirement for the second meeting. So it would be and not less than 10 days after the meeting, and notice of the second meeting not less than 10 days, or not less than 10 days before. Sorry, let me pull up the bill just so I have the exact wording.
Yeah, it's on page 2, line 23. And what CAI is suggesting is language like this. In addition, an additional meeting called under subparagraph 2 in this paragraph shall occur not less than 10 days after the initial properly called meeting. And in David's bill, it is currently 15, but CAI is suggesting 10 to make that consistent with language in the following paragraph that talks about the separation of the two meetings being 10 days as well. Matthew, go ahead, Matthew.
So the paragraph 1 requires that the additional meeting called shall occur not less than 15 days after the initial properly called meeting. Paragraph 2 is specific to the notice, the separate and distinct notice required by the bill of the subsequent meeting.
Correct.
So notice needs to be provided not less than 10 days before the additional meeting, but the meeting itself not occur and would have to occur not less than 15 days after the initially called meeting.
Right, and I'm going to, not to put words in your mouth, David, but I'm going to assume that you wanted the additional 5 days in there for something or another. But so, David, since it's your bill, if you could, give us your opinion on the suggested amendment by CAI, and then I'm going to go to Delegate Weibel.
Thank you. No, you took the words out of my mouth. I mean, I think that the idea of having those extra 5 days just for scheduling purposes and to make sure there's, reduced kind of a communication breakdown is exactly why there's that additional 5 days.
I can read your mind, David. That's because you're a friend of mine. Because you're a friend of mine. Delegate Weibel?
Yes, thank you. I just want to paint a scenario to see if I'm understanding this correctly. So say you have a 10-member association, 5 people show up to the meeting. It's not a quorum, right? Because you don't have a majority. So they adjourn, walk out their meeting room, and lo and behold, the 6th person shows up late. Are you saying this bill would forbid them from then having that second meeting or calling that meeting then at that point? Or are you looking at something totally different in this bill?
At that point, they would need to reschedule the meeting in not less than 15 days and notify the community so that people can be there. The reason for this bill, Delegate Weibel, is because there have been some occasions where some of the associations have used like the scenario that you just talked about, but they've used that in a nefarious way. They've like planned that late person showing up, or they've planned to, not, if they don't have quorum, just rescheduling a meeting immediately for nefarious purposes. So this just basically puts everything up front and says, puts everything above board. So nobody can kind of work out any, does that make sense?
It does, but I'm thinking, because my experience is with a very small association in Ocean City, and if people drive hours to get to the meeting and somebody gets held up in traffic or whatever, and then, I know what you're saying, but in the situation I'm describing, it's not intentional. It's just somebody's just late. And so under that scenario, they'd be forbidden from then having the meeting, right?
Well, so what I think would happen, first of all, it's great that you're a part of an association that actually is concerned about it, and that people do show up. But what I would say is, in that case, they could just keep the meeting open for another 5 minutes if the person's running late. The idea is to stop associations from coordinating and doing what you just said on purpose, which it's great that yours doesn't do that, but there are some, if they want to pass or do something specific, they will actually coordinate. Oh, I was late. They'll do it on purpose. And that's what this is designed not to do. In your case, you just call ahead and said, hey, I'm running a little bit late. Can you guys have a cup of coffee and wait an extra 5 minutes? And then that's fine.
Okay, thanks.
And one thing,
Matthew, go ahead.
One thing I would note is that reading the bill, it looks like this is really in some ways trying to make clear what is the intent in current law. There is a requirement that the subsequent meeting would be by majority vote, the unit owners present in person or by proxy, call for the additional meeting, and then requiring this 15 days notice of the time, place, and purpose of the additional meeting be delivered in a certain manner. But this isn't, I think the intent was that there be a 15-day notice of a subsequent meeting.
Yes.
Under current law, this
Correct.
is just reinforcing that almost.
Clarifying.
Correct.
Yeah.
Correct.
Okay.
Any additional
In my
discussions?
interpretation.
Any additional discussions on this particular piece of legislation by the subcommittee? Are there any stakeholders that would like to weigh in on this particular piece of legislation? I think that since we've had this bill previously and it passed the House by such a large margin, we might want to just go ahead and pass this bill out. I would think.
Move the bill.
Move favorable.
All in favor of HB 593 signify by saying aye.
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 Opposition, Neil?
Yes, sir.
Why? Like, why?
More regulations. We don't need it.
Yeah, okay. All right.
Thank you.
All right, ladies and gentlemen, HB 593 has passed by a significant margin. And I do appreciate all of you attending our meeting this afternoon. Please stay tuned. We have several other bills that we need to discuss, and we'll get back to the two previous bills after we obtain additional information, okay?
Thank you.
Matthew, go ahead.
Just one point, because there were two meetings put on the schedule today, one for 11 and then one at 5, and the 5 was meant, or that later meeting was meant to be a follow-up. I'm assuming that there's not going to be a follow-up meeting?
Yeah, I don't think we have a necessity to have a 5 o'clock meeting for the two previously discussed bills, because we have to collect data in addition, for the additional meetings for us to have further discussions. Is that the kind of what the subcommittee thinks as well? Anyone? Okay, thanks, Jan.
I just meant to clarify for.
Thank you.
That's perfect. That's perfect. And then, so ladies and gentlemen, I appreciate your time, and we will all have additional discussions about these later. I shall see all of you at 1:30.
Bye-bye.